Begin the review lecture for Module 7, which covers an overview of civil rights and civil liberties. So right now we're just sort of glossing the surface of topics that we cover in greater depth in other modules. Our first topic is kind of one where we're going to be making some definitions of things. First of all, what do we mean when we say civil rights or civil liberties? Civil rights are a reference to the limitation on governments and preventing them from denying equal protection under the law. So that one's more straightforward, and we don't have to spend too much time discussing it. When I'm referring to civil rights, I'm talking about equal protection. The definition of civil liberties is a little bit more amorphous. There really are a variety of different definitions. There's really no one definition that scholars perfectly agree on, but it's not that important to come up with a specific definition if you start to see from the case law how those liberties are interpreted. Generally, they mean the inalienable rights that are referenced in our Declaration of Independence. At the time of our founding, the founding fathers believed in the principle of natural law, which was a rejection of the notion that a citizen's rights come from the king, that a king vests or sort of passes down any right that a subject would have in his kingdom. Our founders rejected that idea through an Enlightenment philosophy that was developing in England, Western Europe at the time, known as natural law. And that's where we get the concept of natural rights, that all rights held by individuals are rights that are inherent in humanity. They aren't handed down by a king. They are just vested in us by virtue of our existence. And if you're a religious person, you might see them as being vested in us by God. That's why our Constitution, or excuse me, our Declaration of Independence refers to nature's God, just depending on your point of view. Our courts have, at different times and in various cases, referred to civil liberties as whatever freedom a person ought to have in order to be considered a free person. So it's kind of an ambiguous definition, but you'll start to see what that word means, civil liberties, as you start to see the cases interpreting various freedoms. Some civil liberties are enumerated, meaning they're listed out specifically in our Constitution. Some are found in the original articles of the Constitution. Some are found in the Bill of Rights of the Constitution. Some are found in other amendments of the Constitution. But there are also several unenumerated rights, those that aren't specifically listed. And those rights come from interpretation that cases and courts have provided over the history of our country. You can be sure, though, that they exist and that the founders intended that they exist or knew or recognized that they existed because of what they wrote in the Ninth Amendment, making sure it was understood their listing of certain rights, their enumeration of certain rights is not and should not be implied to mean that those are all the civil liberties that a person might have. So we have this core understanding from the founding of our country that some civil liberties are enumerated and required a specific they were necessary to be specifically listed, but they weren't all the civil liberties that did exist. Others would be recognized by the courts over the passage of time. We're going to start, though, with the ones that are enumerated, particularly in this module, and then we'll look at the ones that are unenumerated in subsequent modules. Our original articles of the Constitution provide protection for civil liberties in Articles 1 and Article 3. In Article 1, we'll start there. We have protection for a right known as habeas corpus. Protection for this right began as far back as the Magna Carta. That's like in the 1200s. Historically, kings had been known to issue general warrants for the arrest and indefinite detention of an individual without ever affording them any due process rights. So by putting this protection in the original Constitution, our first Congress was hoping to ensure that the guilt of an individual is determined by the judicial branch of government, a disinterested third party, and not by a king, not by the president, not by any officer of the executive branch. So in that sense, it is a separation of powers issue as much as it is a matter of due process, because it is the right to have an impartial panel determine guilt or innocence in accordance with fair law and not have that determined by a member of the executive branch. In Article 1, this is in Section 9, the right is protected in this way. It reads, "The privilege of the writ of habeas corpus shall not be suspended except when in cases of rebellion or invasion, the public safety may require it." That's known as the suspension clause of Article 1. It just means that the right of habeas corpus, the right to have an impartial panel of the judicial branch determine your guilt or innocence, can't be suspended except in very unique circumstances. The balance has to come into play in times of war, when we can't we can't use our civil court system for some reason. In those situations, martial law can be declared and guilt or innocence might be decided by the executive branch. But it is a very narrow exception. The suspension clause is very limited. And yet it has still been used by the government, by the president in a couple of times. And then a notable time in defiance, really, defiance would be the word, in defiance of a U.S. Supreme Court ruling. Abraham Lincoln he did many, many good things. And one of the things that he did, you can decide whether it's good or bad, was to ignore the U.S. Supreme Court and suspend the right of habeas corpus for Confederate soldiers and, well, really officers of the Confederate Army. Most often, though, in modern times, the right of habeas corpus is exercised by criminal defendants. It's typically where a defendant has been convicted of a crime under state law and in a state prosecution. He or she could file a petition for writ of habeas corpus with a federal court, asking the federal court to determine the legitimacy of his or her incarceration. And the only basis for overruling the state's conviction would be if the petitioner can show a violation of a constitutional right. You probably remember from previous modules where we studied the Guantanamo cases involving the rights of enemy combatants and non-citizens to assert the right of habeas corpus. And I gave you in the reading assignment for this module a link to a video that reviews the Guantanamo cases, just as a reminder of what we learned in that other module, and to emphasize that this right is guaranteed not just for citizens, but to people within the territorial jurisdiction of our country. The next protection of a civil liberty from Article 1 can be found here. No bill of attainder or ex post facto law shall be passed. A bill of attainder is when a legislature enacts a law that punishes a person, not just by imprisonment, but with any deprivation of freedom at all. When it has done so, it has enacted a bill of attainder. The prohibition on bills of attainder apply to both the federal and state governments. They're unconstitutional because they would violate both the separation of powers, because it would be the legislature determining someone's guilt or innocence and not a court. It should be a court, not the legislature. So it's a violation of the separation of powers. A bill of attainder is a violation of the separation of powers. It is also a violation of your right to a jury trial in a court. So it's pulling together two different foundations there. Ex post facto laws also are protected from the federal government and the state governments. But these are laws that attempt to be applied, criminal laws that are attempted to be applied retroactively. That's prohibited by the Constitution. If an act is illegal when it was performed, then the actor can never be prosecuted for it, even if a law is passed subsequently that made that action illegal. They can't be prosecuted for it if it was legal when it was done. The ex post facto right, though, applies also to increasing sanctions for crimes. Those also cannot be done retroactively. Article 3 of the original Constitution also has some protection for civil liberties, including the right to a jury trial and criminal prosecutions, and rules for the prosecution of the crime of treason. There are some limitations there addressing it. It defines the crime of treason, and it also provides a due process rule about on what basis a criminal conviction could be based on. It has to be based upon the testimony of 2 witnesses or a confession in open court. So this is just a limitation on governments in their ability to prosecute the crime of treason. That's given in Article 3. And those are the ones that the ones I've listed there: the habeas corpus right, bills of attainder, ex post facto laws, jury trials, and the crime of treason. Those are the ones in the original articles of the Constitution. So there is some protection for enumerated civil liberties in the original articles, but the ones you're probably you would probably recognize most are the ones that are provided in the Bill of Rights. If you recall, when we were studying in previous modules, the Bill of Rights were a measure insisted upon by anti-federalists. A few states refused to ratify the original Constitution because it lacked a Bill of Rights. These anti-federalists thought that the original articles didn't provide enough limitation on the power of the national government. So they insisted on some amendments to the Constitution. And upon the ratification of the Bill of Rights, these states agreed to ratify the Constitution. So it was a sort of a conditional ratification on their part. But it is an effort to limit the power of the national government, not state governments. State governments already had constitutions that provided protections for civil liberties. So it wouldn't have been seen as necessary at that time to extend the Bill of Rights to state governments. So originally, these were protections just against the actions of the federal government. I've listed them all here. You should try to memorize in a very general sense what each of these amendments protects. Subsequent modules will go into depth on definitely the First Amendment, and then the Fourth, Fifth, and Sixth and Eighth Amendments. They are addressed in Module 13, I believe. The others we'll talk about more briefly in this module. So we'll start with the Second Amendment. The Second Amendment is written in sort of an odd way. It's got two clauses, the prefatory clause, a well-regulated militia being necessary to the security of a free state. That's called the prefatory clause. And then the operative clause, the right of the people to keep and bear arms shall not be infringed. So those two clauses and the fact that it was written in that way with this prefatory clause and the operative clause has led courts to draw different conclusions about what the Second Amendment really protects. What does it really mean? So I'm about to tell you the arguments, and then I'll get to what the conclusion is. The one argument was that the prefatory clause limits the meaning of the operative clause. And if you think about it for a minute, there's some validity, a great deal of validity to this argument. Originally, the point of the amendment was to place additional limitations on the power of the federal government. I just emphasized that in a moment ago. So if you think about it from that mindset, the clause makes sense. States could not guarantee their own power as sovereign entities unless they could protect themselves militarily. And at that time, their military took the form of a militia. If their militia couldn't bear arms, then the state could not protect its own or guarantee its own power against a federal government. So there's your argument that the prefatory clause is really limited to the ability of states to arm their militia, that it is actually a collective right and not an individual right. But the operative clause, or the two clauses could also have this alternate interpretation, which also makes sense. At common law, individuals were permitted to own and use weapons without a whole lot of government interference. To deny an individual the ability to have a gun would deny them the ability to provide for their families or to protect themselves. How could someone hunt for food if they didn't have a gun? Or it'd be far more difficult, or some sort of arms. How could a father protect his family if he did not have a gun? There were no police forces at the time. So the right of self-defense was necessary for the protection of a family. So from that point of view, from that mindset, you can see a meaning in the Second Amendment as an individual right, the right of individuals to self-defense. So you have these two contrary interpretations of the Second Amendment, and there's still a little bit of controversy in this interpretation. It may be a bit inflated in the media, but it's still there. However, in 2008, the U.S. Supreme Court really they have settled the debate. This is the interpretation is that the Second Amendment protects an individual right to bear arms. However, in this case, I'm referring to the case District of Columbia versus Heller. It involved a law that, in effect, prohibited the possession of a gun even within your home, inside the privacy of your home. You could not own a gun under the laws of the District of Columbia, which, when that law was written, had the highest murder rate in the entire United States of America. It was a dangerous city to live in, and this law was intended to protect citizens, not deprive them of their rights, but to provide them with protection. However, their law, according to the U.S. Supreme Court, went too far because it banned or prohibited the right of self-defense within your own home. So it was a 5-4 split. So a narrow majority of the court held that the Second Amendment protects an individual civil liberty, the individual's right to own guns. However, the court said this right can be regulated. There can be some reasonable restrictions on the right to bear arms. And the majority gave some examples of valid laws, valid regulations, or restrictions on the right to own a gun. Own a gun. But that type of restriction, or the restrictions that were in that were at issue in the Heller decision had gone way further than just some sort of like a background check or things that exist today. That the law in the Heller decision was in effect an outright ban. So short of an outright ban, what restrictions can there be on the right to bear arms? That remains to be decided. A couple of years ago, almost 2 years ago, the U.S. Supreme Court addressed the extent of regulations and tried to provide kind of a threshold understanding of when a regulation goes too far. That was the case of New York State Rifle and Pistol Association versus Bruen. As shorthand, it's referred to as the Bruen decision. And in that case, it involved a New York law that required people to kind of give a special justification for their ability to carry a concealed firearm outside the home. So we're not restricting the right to own a gun and keep it in your own inside your home for your own self-defense in your home. This was about the ability of law-abiding citizens to carry a concealed firearm outside their home as they go out and interact with the public in public settings. And under New York law, there was a rule that you had to provide, I've forgotten the exact terminology, but it was some sort of special justification that you actually, even when you're outside your own home, you needed to have a gun to protect yourself for some reason. So the Bruen decision said that that regulation went too far. And their reasoning was that there was no historical analog for that type of restriction. They court, this is a decision written by Clarence Thomas, and Clarence Thomas is, he is sort of a champion for the more restrictive interpretation of the Constitution and believes that to interpret it properly, you must set it in its historical context. So to define the meaning of the Constitution, you must look at what it meant when it was ratified. So he goes and looks back at the laws that existed in 1792 when the Second Amendment was ratified and saw no historical analog for the type of regulation that the city of New York had attempted to impose. So on that basis, he and a majority of the court struck down the New York law and kind of gave us this test for when is a regulation going to go too far. For it to be valid, a state regulation of the right to bear arms must have a historical analog. There is a case currently pending before the U.S. Supreme Court where they will apply the Bruen decision to a law. I think it's on the books in Texas, but I think several states have a rule that when someone becomes the subject of a domestic violence restraining order, the police can indicate on the restraining order that that person loses the right to own a gun or to possess a weapon. And it's intended to protect the victims of domestic violence. So it gives police the ability to provide greater protection for battered women and children mostly, but it's not exclusive to gender. Anyway, many states have this type of rule that when a person becomes the subject of a restraining order, they might lose the right to possess a weapon. And that rule is what is pending before the U.S. Supreme Court, whether that type of regulation is valid under the Second Amendment. And so applying Bruen, the argument will have to involve some historical analog for that type of restriction. And we'll see what the court does with that one. You should see a decision over the summer about it. There are other amendments to the Second Bill of Rights that provides protection for civil liberties. Several amendments, particularly the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, address to an extent some civil liberties. They're mostly focusing on the right to vote, like the 15th Amendment, the right to vote, the 19th Amendment, giving women the right to vote. So the right to vote is a fundamental freedom, a civil liberty enjoyed by all peoples. But each of these other amendments have a clause added on the end that looks something like this, that Congress shall have the power to enforce by appropriate legislation the provisions of this article. Okay, so that enables Congress, it extends the power of Congress to make laws that carry into effect what the amendment is trying to accomplish. So you would see the enabling clause attached to the 14th Amendment. Like that's where I'm quoting here. That language on the slide comes from the 14th Amendment. So it gives a basis for Congress to pass new laws. It gives Congress a little bit greater power than it has under Article 1 to carry forward the intent of these amendments. And on the basis of those clauses, Congress has passed certain measures intended to protect civil liberties. States in the Bill of Rights. As I mentioned earlier on in this lecture, the intent of the Bill of Rights was just to further limit the federal government. It was something that states' rights advocates, anti-federalists insisted on for the ratification of the Constitution. And the U.S. Supreme Court decision Barron versus Baltimore describes that, kind of gives us a constitutional basis for that type of interpretation. States had their own constitutions where civil liberties and rights were protected, and the Bill of Rights did not apply to the states. But during Reconstruction, it became starkly clear that state governments were going to violate civil liberties of former slaves. The former Confederate states got busy even after the ratification of the amendments, trying to limit the rights of former slaves. But the passage or the ratification of these three amendments was in part a means of ensuring protection from the activity of state governments. So the 13th Amendment forbids slavery by anyone or any institution anywhere in the U.S. So it's the 13th Amendment is not limited to just state governments, but it does include state governments. So both the federal and the state government cannot uphold slavery under their laws. The 14th Amendment, I'll get to in just a minute. It's got a lot in it. And then the 15th Amendment is the protection for the right to vote, which applies to national and state governments as well. So we look at the 14th Amendment, and it would seem pretty easy to conclude that the 14th Amendment would incorporate all civil liberties that could ever possibly exist. But that is not how it's been interpreted. The 14th Amendment starts out by defining citizenship. So the Dred Scott decision said that slaves were not citizens, and the 14th Amendment overrules the Dred Scott decision and says, no, all persons born or naturalized in the U.S. are citizens of the United States. So they would all be afforded protection for due process and equal protection. The 14th Amendment contains the Privileges and Immunities Clause. It contains also the Due Process Clause, which reads, "Nor shall any state deprive any person of life, liberty, or property without due process of law." This is the mirror image of the Fifth Amendment, and it is explicitly for state governments. Last, the Equal Protection Clause states may not deny any person within its jurisdiction the equal protection of the laws. So I said you could look at the 14th Amendment and think, well, having this due process clause means any civil liberty that exists cannot be infringed even by state governments. But that is not how the U.S. Supreme Court interprets it. For better or for worse, the court has to go a second step and determine whether a due process liberty is so fundamental that it is within the scope of the Due Process Clause. This is called selective incorporation. They have to do this extra step of analysis, and they do it on a case-by-case basis to determine whether civil liberty is protected by state governments as well as from national governments. And there's kind of an I guess you would call it a test or a framework for analysis when determining if a law is so fundamental that it would be part of the 14th Amendment. Is it a fundamental principle of liberty and justice when inheres in the very idea of free government? And is the inalienable right of a citizen of such a government? That comes from the Twining decision, which has been overruled, but still helpful to consider what we mean by fundamental and selective incorporation. In practice, when courts are determining what rights are protected by the common law of the states, they are going to look at the history and tradition of our nation. So they will go back and consider what the state of affairs was when the 14th Amendment was passed to determine whether this civil liberty is one that states would and should recognize, that would have been within the intent of the drafters of the 14th Amendment. And so far, on this case-by-case basis, the court has selected nearly every civil liberty found in the Bill of Rights or in the common law. Not all of them, but most of them have been incorporated on a case-by-case basis. And that is selective incorporation. That's just a reference to how courts go about determining whether a due process right is within the scope of the 14th Amendment. Now for civil rights. Fortunately, the more straightforward aspect of the 14th Amendment, equal protection. This clause, as you know, was originally intended to protect former slaves from discriminatory state laws. But in modern times, it prevents state governments from enacting laws that discriminate on the basis of more than just race, any suspect classification. A classification will be deemed suspect if it refers to a group of people who have historically been disenfranchised, meaning they could not vote on the laws of their state. So this application, it really avoids a separation of powers violation. If you think about it, we're talking about invalidating a state law, and state laws are passed through the democratic process. That is the business of the legislative branch of government, to make laws that reflect the will of the majority. And yet, applying the Equal Protection Clause, courts are undoing that law. They are undoing the result of the democratic process. So it can be seen as judicial activism, as the courts stepping out of their sort of realm of authority and interfering with the activity of state legislatures. But we avoid that interpretation where we limit this equal protection to groups or classifications that are based on race in particular, because African Americans weren't part of the democratic process to make the law. So if a group was not able to participate in the democratic process that yielded the law, then the law cannot fairly discriminate against them. That means classifications based upon race are obviously suspicious, obviously should be overruled and invalidated. As the first consequence of the 14th Amendment's ratification, states could not enact laws that on their face were discriminatory. That is known as de jure discrimination, of law discrimination. So a state law could not say, we will treat African Americans differently from Caucasian or white Americans. That would be a de jure discrimination and plainly illegal under the 14th Amendment. And so any law that states had on their books that that provided for some sort of de jure discrimination immediately were invalidated by the ratification of the 14th Amendment. However, Confederate states got around that fact by writing laws that were neutral in their words. So they didn't appear to be discriminatory in their words on their face, but they were applied in a discriminatory fashion. And that's called de facto discrimination. And that's how the South got away for so long with the Jim Crow laws that limited the rights of African Americans and prevented them from voting. This is the basis for the separate but equal doctrine that you should be familiar with from the Plessy versus Ferguson decision, where blacks and whites are given the same services, but they're given in separate locations. And as long as both locations were equal, they were considered legal, or the practice was considered legal. That was the separate but equal doctrine. It lasted about 60 years before we got the Brown versus Board of Education decision, where the court called out the states for what they were actually doing. The services were not equal at all, and they were based upon invidious discrimination and therefore struck down. I want to go back for a minute to the Privileges and Immunities Clause in the 14th Amendment. I just want to, all you really need to know about that is that there is no clear definition of what this means. We haven't seen it interpreted often enough to really give us a settled rule on what it means. There's just not enough case law to provide guidance there. Just know that what it doesn't mean that all civil liberties are protected by the 14th Amendment. It cannot be interpreted that way. The Supreme Court has said at least that much. But moving beyond the 14th Amendment, we'll talk about equal protection a little bit more. Protection for civil rights and equal protection can also come from laws that were enacted by Congress. So not just the Equal Protection Clause, but also by legislation enacted under the authority of the Commerce Clause. If you remember in previous as Module 4, where we were talking about the power of the legislative branch to enact laws that affect interstate commerce, some civil rights legislation was passed under that authority. And then, as I mentioned, the Reconstruction Amendments enabling clauses gave authority for Congress to pass laws that protected citizens from unequal treatment. But each of those two sources have their own limitations involved. And so you first have to consider the source of the law. What authority did Congress have for passing the law? And then you look at what the limitations may be on that authority. The 13th Amendment, as I mentioned previously, applies to all governments and protects all people. It originally only prohibited actual slavery, but has been extended to prohibit even the word was vestiges of slavery, the lingering effects of slavery. That was, let's see, the example that the case that was given in the textbook was Jones versus Alfred Mayer Company. But there just aren't very many cases that I'm aware of that really interpret what we mean by vestiges of slavery. It's just not used as much as the 14th Amendment and the Commerce Clause are used. So we'll go back to them. On the authority of the Commerce Clause, excuse me, the PowerPoint jumped to the 14th Amendment's Equal Protection Clause. Okay, so what limitations are associated with that source of authority? Well, it's limited to state government action, not the activities of private citizens. So if you look at legislation passed under the authority of the Enabling Clause in the 14th Amendment, you must find state action doing the discrimination. In the civil rights cases of 1883, the court made it clear that The 14th Amendment's Equal Protection Clause does not limit the activity of private citizens. All right, there was the 15th Amendment. My slides have been mixed up. I'm sorry about that. It applies to all governments, but targets racial discrimination in voting. Here's where I was hoping to get to, the Commerce Clause. The Commerce Clause doesn't have that same limitation that is inherent in the 14th Amendment. We don't have to have state action now. Under the authority of the Commerce Clause, Congress has passed several civil rights laws, and they apply to private businesses, to private individuals. But it still has some limitations I'll get to in a second. So this started happening in the 60s with the civil rights movement. There was enough political will through the activities of citizens to convince Congress to pass laws that really brought the 14th Amendment into its fullest meaning. They had to use the Commerce Clause to get it done, but they got it done. So you have the Civil Rights Act of 1964. It's got several different aspects to it, requiring equality and public accommodations, which would be hotels and restaurants, public facilities like parks, schools, employment. Then we had the Voting Rights Act, which ended Jim Crow. Any restrictions on voting in law or in fact would violate the Voting Rights Act. The Fair Housing Act ended discrimination in the real estate industry, such as redlining, something you might be familiar with. That was banned by the Fair Housing Act of 1968. But here's your limitation. In order for the Commerce Clause, or in order for a law to be valid under the Commerce Clause, the discriminatory activity must, in the aggregate, substantially affect interstate commerce. So you might remember from Module 4, when we were looking at the Commerce Clause, we were looking at economic regulations, the regulation of businesses. And we saw several examples of where Congress's laws were upheld or denied, depending upon the extent of the activities intertwinement with interstate commerce. Well, now in this situation, we have Congress passing laws prohibiting discrimination. And they don't have to, the discriminatory activity doesn't necessarily have to be economic activity. It can be non-economic activity. It can be practiced locally and at the local level, but it still must, in the aggregate, substantially affect interstate commerce. And that's where we got those cases, U.S. versus Morrison, U.S. versus Lopez. They demonstrate that limit. The Morrison case was the Violence Against Women's Act. And there just wasn't enough of an effect on interstate commerce involved where rape was concerned, or where in the Lopez case, where gun possession was concerned. There wasn't enough of an effect on interstate commerce for Congress's law to be valid under the Commerce Clause. So that Congress had to go back and find another basis for its power to enact those types of laws. All right, now this last topic of equal protection was a study of same-sex marriage. And the textbook was published before the most recent cases involving same-sex marriage. And that's why I had to add on a couple of things for you guys to read, including the Obergefell versus Hodges decision. And it says 2015, it may be 2016. I get the date mixed up there. But it was in that case where the U.S. Supreme Court found that prohibitions on same-sex marriage violated both the fundamental right to marry and the Equal Protection Clause. So both of those clauses of the 14th Amendment are violated by a state law that prohibited same-sex couples from receiving the civic benefits of marriage. This ruling does not apply to private organizations. The Supreme Court was very careful to note that this does not require churches to recognize same-sex unions, and it will never be applied that way. It only, because this is based in the 14th Amendment, it can only apply to state action. There was a subsequent decision, the Masterpiece Cake Shop decision from 2018, and you've got to limit it. It was unique to its facts. And so you have to understand what were those facts. This was a situation where a small business owner who was a bakery, decorated wedding cakes, a homosexual couple came into the bakery, asked to have him decorate the cake for their wedding. And under Colorado law, same-sex marriage was allowed. And the cake or the bakery owner refused to do it because of his religious belief about same-sex unions. And they were angered by that, of course, and they reported what he did to the Colorado, it's called the Colorado Civil Rights Commission. The commission enforced Colorado's anti-discrimination laws. So they reported the baker to that commission, and then the commission, so this is like a state agency, evaluates what the baker has done and determine whether he, the baker, violated Colorado law. And in the hearing before the commission, the U.S. Supreme Court has in that decision sort of a transcript of what happened during the commission's hearing. And the things that they said about the baker made it pretty plain that they were not acting in a neutral way. They were being harder on him than they would have been on another business who had come before them in a hearing. And so the reason the Supreme Court ruled the way it ruled was because of what the commission did. They discriminated against the baker because of his religious beliefs. And in that sense, it was a violation of the First Amendment. So we aren't dealing with the Civil Rights Act itself. We aren't dealing with the Commerce Clause. We aren't even dealing with the 14th Amendment. They're dealing with the First Amendment, the discriminatory activity of a state government agency involving a religious belief. So limit it to those facts. And don't be careful not to extend it beyond those facts. However, you kind of get a flavor for how the U.S. Supreme Court is going to handle situations where there's a conflict between two civil liberties. You have the civil liberty, the right to marry, that must be balanced against the civil liberty of religious freedom. And it's going to be difficult to balance those out. I'm not sure it's come before the U.S. Supreme Court, but you kind of see in this Masterpiece Cake Shop an example of how the court might balance those two civil liberties. That is the end of this review lecture for Module 7.